Hey everyone, thanks for joining us. This is the long-awaited session. We booked it back in May with Holly Terrell, special education attorney. And today we're going to be talking about Endrew F., a landmark decision in the disability community. And, I think some clarity or conversation deserves to be had around it. So thanks for coming back, Holly, and joining us.
Thank you.
I hope you've had a good summer.
I have had a summer probably much like everyone else's summer. It's been very long. So yeah, it just feels like it's been summer for a very long time. But,
I definitely agree with that.
Yeah. I thought I might have a couple of children making their debut today, but I found someone to help me out with that. So that's good. I do have a cat that might circle around at some point. So
I've had my son pop in a few times.
Yeah.
But let's talk about Endrew F. So I want to say Endrew F. came out in 2017. Is that right?
Look, I can get you the exact date. I pulled up. But yes, it was argued, decided March 22nd, 2017. They actually argued it in January, so they came out with the decision rather quickly.
Yeah. So just for people who might not know what Endrew F. is, what is Endrew F. exactly?
It's a Supreme Court case, U.S. Supreme Court case, which is, a really big deal for the Supreme Court to take any case is a huge, huge thing for them to even look at it. And so this was like you had mentioned, it was decided in 2017, and it dealt specifically with the standard for faith. And the decision is unanimous. It's delivered by Roberts, Chief Justice, and so but it's so for. I mean, unanimous decision is a big deal. I mean, that's pretty set in stone there. And for them to all get on the same page, which I think we were discussing, it's interesting. Sometimes people from both sides, and I say both sides, or both parties, both different politics, can get on board when it comes to special education issues. Sometimes the way they're implemented and other things, not so much. But I do see people reaching across the line a little bit more, I think, when it comes to getting these things done. And I think the fact that it's a unanimous decision is pretty cool and indicative of that. So, yeah.
So I know some of the history of the case. So it took 7 years from the beginning of their case, if my memory is serving me correctly, to get to this Supreme Court decision.
Probably. I know that just going to federal court in the Southern District can take a number of years. And that's, not always the first step. First step is usually the due process hearing. So, you go through the due process hearing, and then, which takes a little while. And then let's say someone appeals, you go to the Southern District where I am. In Texas, the way our system is tiered, we when we appeal, we go to the federal district court. And then it can be appealed from there to the Fifth Circuit, and then it can be appealed from there to the Supreme Court. So there are a number of steps and a lot of work for the attorneys. It's a lot of work getting prepared for a due process hearing is a lot of work. So all of that takes a while, and so it does not surprise me at all whatsoever that it would take this long. And in 7 years, I mean, the kid is 7 years older, so they're not in the place. So I am very humbled and grateful to people who make this type of sacrifice, knowing that it's not going to directly benefit them so much because of the length of time. It's they are doing it for the better good, and very, very grateful for the type of people who do these things. This family.
So what I know is that it was a Denver-based, or Douglas County, which I think is the city of Denver, Colorado, based case. It was an autistic boy. His name is Endrew.
Yeah.
The family's last name was withheld, at least for the longest time. The family had tried to get him services through his school. They kept hitting walls. They pulled him from the school and they put him into a private school. But they had the means to pursue action against the school that had failed their child. So they filed due process. What I read about them is, really they just took it the length. And like you said, they knew that it wouldn't benefit their son, but they were unwilling to stand for what had happened to any other child. So the issue was that their son wasn't, it was like he was sort of dismissed of, oh, he's autistic, so we just don't have to try enough, which is why Chief Justice Roberts put in that de minimis language, is my understanding, within his decision.
Yeah. If you don't.
No, go.
I'm bad at that. The de minimis language, so this is a 10th Circuit case, or it was. And so when the U.S. Supreme Court is looking at it, it's coming up from the 10th Circuit. And, before that, they have the district court and everything like that. But, and the standard at that time was the de minimis standard. And it's more than a de minimis test. And that's the test that the 10th Circuit applied. And that's what the Supreme Court was looking at, is this the right standard? Is it not? And they found that it was not the right standard. And let me see if I can find the actual, this is from the opinion, the Endrew opinion, and it talks about the 10th Circuit affirming the lower district court's decision, and says that the 10th Circuit interpreted Rowley, which is the case that set the standard for FAPE before Endrew. They interpreted Rowley to establish a rule that a child's IEP is adequate as long as it is calculated to confer an educational benefit that is merely more than de minimis. And they concluded that Endrew's IEP had been reasonably calculated to enable him to make some progress. And that's why the 10th Circuit said that he received free appropriate public education. And the Supreme Court said no, that wasn't enough. And then they gave the new standard that we have today in Endrew. So, which, you can say it if you want to say the new standard, but yeah.
Yeah, part of their history too is they put him in a school that had an annual tuition of $70,000 a year. And the child started to have immediate improvement as well, versus, the almost non-existent improvement that he had before. Like you said, they were defeated in 3 courts before they went to the Supreme Court. But less than 3 months later, the Supreme Court issues a unanimous ruling citing on behalf of the family. We did have one question come in. Heidi, yes, the family was paid $1.32 million in settlement after the Supreme Court decision.
That is information I wasn't aware of. That's pretty, that they did get some benefit from it, which is nice. And that can happen, but it's definitely risky when you're going to a court after court after court. So
yeah,
this is a decision that the federal court, the U.S. Supreme Court, in my opinion, they had to make this decision because they had, the circuit had to follow Rowley before then. Now, how they interpreted Rowley and everything and applied the facts to the law is up for discussion, I guess. But yeah, it's really cool to know that every justice's eyes were on this topic, and because I don't know about you, but we both have kids who have some special needs, and I don't really feel like these issues get enough eyes, and to know that Ruth's eyes were on this, Chief Justice Roberts, like all their eyes were looking at this, and they were discussing this one thing for a period of time, just almost takes my breath away. So it's very, very important to me. So.
I mean, I remember when the decision came out, the ripple effect within the community from an emotional point of view of like, finally, yes, something more than. But being an advocate and sitting in IEP meetings, and having looked at the school team and gone, guys.
I agree.
No, you need to do a child with what you're claiming is an average IQ, which I claim is an above average IQ because we disagree on how the IQ is being interpreted, shouldn't be reading multiple grade levels behind the grade that they're in. He's capable of significantly more. You're not even pushing him to what the standard should be. You're accepting less than. You're in direct violation of Endrew F. And they just kind of go, eh.
And I'll go ahead and I'll just so we have it out there. What the standard is, the Endrew standard to meet their obligation under the IDEA. The school must offer an IEP that's reasonably calculated to to enable a child to make progress appropriate in light of that child's circumstances. So it sounds a lot better than what was it? Educational benefit that is merely more than de minimis. From a respect angle, I feel like it's a much more respectful standard, which is important to me in a way. I want my child to be respected, and it sounds more than de minimis. It sounds very disrespectful in my opinion, and so there's that, which is good. Going back to, or kind of I think what you were touching on, is how it's changed the landscape in special education. And I don't want to be Debbie Downer, but I don't know. At least where I am, I don't see a lot of changes. I do like. I think it is helpful that we are more focused on progress than educational benefits, because I think they're different. I think a child being exposed to anything bestows educational benefits. Does that mean that he's making or she's making progress on their goals, these goals that we agreed on, that we set out? No. So I think that this does make it easier to argue. Like, I do due process hearings, so that's what I think about. But I can set down the PLAFs, and then I can look at the goals, and then I can go, and there's like a circular thing. Actually, I think I made a demonstrative of the of an ineffective. I think I might have sent it to you. An ineffective IEP, where if one of those pieces is not right, like the PLAFs aren't right, or the goals aren't right, or the progress notes aren't right, we're not keeping good data, it affects all those other pieces of the IEP. And so now, for me at least, it's easier to go into those things and have a little bit more structure. And although it's a very subjective standard still, to me it feels more objective than it was, if that makes sense.
Yeah, no, I think it does. But that leads me to a question that you and I kind of touched on when we talked last night, because you are doing due process hearings. We're 3 years out now from the Supreme Court decision. Have you seen, has it impacted change?
I haven't personally seen a lot of difference in the decisions. I'm one attorney. I'd be interested to take a poll of all the attorneys,
Right.
10, 15 attorneys that do what I do in Texas. They might have different opinions on it. I personally haven't really seen a lot of difference because it is still very subjective. And so, the jurisdiction you're in, the jurisdiction we're in is kind of a tough one. And so it might, and so in different states, it might be totally different. This might have had a very large impact. I don't know because I don't practice there, but in the state I'm in, I haven't really noticed a big difference. I like it because it does make my job much more, I feel like I have an easier time arguing things and an easier time setting up what I need to set up for an appeal later. Like if I need to do that, so that's easier, which is always an option. So kind of have to look forward to that. But not still pretty subjective. And I was actually going to kind of go down to another place in this opinion, if you don't mind giving me a second.
Yeah, no, please.
They talk a lot, which is good. Yeah, good stuff. They had said something about the actual standard and the subjectivity of it. They do mention the IEP must aim to enable the child to make progress. And there's one thing in here that, okay, it's actually on page, if I can find the page of the opinion it's on. It's like page 15. And the court says, we will not attempt to elaborate on what appropriate progress will look like from case to case. It is in the nature of the act and the standard we adopt to resist such an effort. The adequacy of a given IEP turns on the unique circumstances of the child for whom it was created. And then they say this absence of a bright line rule, however, should not be mistaken for an invitation to the courts to substitute their own notions of sound educational policy for those of the school authorities, which they review. And that's actually from Raleigh. So the Supreme Court knows that this is a subjective standard, and I don't know how they would totally get away from a subjective standard like we have, because that's the whole point of the IDEA, is to look at the individual child. So it is going to vary from child to child to child, and that's really good. But it also makes it really difficult when we're trying to figure out this what this FAPE standard really means.
So I'm going to hit you with a question that I haven't told you I was going to ask you because it just popped into my head. Sorry. So, I mean, obviously I do a great deal of reading, right? And I've been pretty deep lately into studying Seidenberg's book, Language at the Speed of Sight. And in reading his book, after having read several others and several different scientific papers, I was at a place where I was like, he said something in particular that made me go, I think I finally understand what the issue is. Because you do hear people say, oh, dyslexia is not real. I mean, because this page is very specifically dedicated to what I call the D. So, dyslexia is the heart of that. So we know for a fact that dyslexia is real. The scientific community is very agreed upon that fact. What Seidenberg was able to point out, though, was that the prevalence of dyslexia, or maybe necessarily whatever the finite definition of dyslexia is up for debate. They agree on many facets, but they don't agree, like in totality, if you will, on how necessarily to define it. Yes, the International Dyslexia Association has a definition, and the neuroscience community has a rough definition that they're sort of working around, but being scientists, they haven't gotten to this place of complete totality. Dyslexia is definitely a definition of privilege, because then if you go into an underfunded school in a poor community, the definition doesn't help, because then they're arguing that the children maybe haven't had enough opportunity, therefore, in order to be able to define the LD. So you can't, in that particular situation, you can't, for lack of a better phrase, weed out the LD from those that are just not being given adequate opportunity, which again makes the whole argument for structured literacy even that much more profound. But the point that I want to get to is, when I was reading what Seidenberg had written, I was like, that's the problem. Education's argument exists within the gray space of where the scientific community doesn't agree on certain facets about what dyslexia is and how necessarily to define it or work with it. And because it is an individual-based thing, no two children are exactly alike. Whether they're normative or dyslexic, it doesn't matter. No two children, no two brains are exactly alike. That's where they anchor their denial, and that's where they're anchoring their antiquated view. And we need decisions like Endrew F, but we need more, I think, in order to really, we either need the scientific community to come together and say, okay, here's the plateau, here's everything that we definitely agree on, and here's the gray space that we're still studying. However, we know all of this, so you can't deny all of this. And, we almost need the laws necessarily to back it. I mean, IDEA is great. And I know Sally Shaywitz said at one point that she feels like IDEA needs a 14th definition, because dyslexia needs to be the 14th classification. It doesn't need to fall under specific language disability, because the way that Bennett Shaywitz describes it is saying, specific learning disability. The way that Bennett describes it is saying specific learning disability is like saying somebody has a cold, versus saying dyslexia is like diagnosing somebody with strep throat. So there is a question in there.
I'm kind of scared of the question now.
So from your experience as an attorney representing families like mine, no, you're not my attorney. No, you haven't represented me in anything, but you do represent families like mine. Do you find that? Do you find that the denial and even some of the decisions that are made are just because it's seated in that gray space of their inability to agree, or is it something else more profound?
And this question is specifically with respect to dyslexia, or just
yes,
overall?
I think dyslexia, if you can make it overall, then do, but let's do dyslexia first.
Okay. First, we'll do a bigger picture, whatever I'm about to point. So there is a difference between, let's say the DSM, what the DSM says, autism, that's a big one. Their criteria for autism, and where where the school goes in and does an FIE and determines whether the child has autism as a criteria for to qualify for services under the IDEA. So there is gray space in there, and I know that. So that's one, bigger area, and that happens with a lot of different things. I know that a lot of times I will have schools come back and there will be a child who really needs help with reading or whatever, math or whatever it is. And so they do they do a KTEA, like an academic, the test, on reading and all the different things. And then they do the intelligence test, a whisper or something like that. And then in order for them to in order for them to recommend, the art committee accepts, a certain criteria for the child to qualify for special education. One of the, I can never remember what they're called, but one of the things under the intelligence test, like the crystallized intelligence, working memory, those things, they have to match up with whatever problems the child is having in reading or math or whatever. So, and they're different. And I don't know which ones match up with which. I have to figure them out for every single case and talk to my, people who know. So I know that is one way that the child will not be identified with a specific learning disability if, they're not having a problem with this specific, processing speed or whatever it is. And so that's a way that won't happen, and that happens pretty often. With respect to dyslexia is a different animal. And I know that there's a lot of back and forth, should it be a learning disability under, like a SLD in reading? Should it be different? I know that in Texas, at least, a lot of the kids, sometimes just almost all the kids with dyslexia are under 504 and not under, they don't have IEPs, and they'll receive services under 504, which, by the way, you can receive anything under 504. You just don't have the protections, and you usually don't receive as much, just for a practical matter.
Right.
Now I'm trying to answer your question. So if you could kind of guide me in the direction, because I think I'm getting off a little bit. So kind of guide me back.
No, I think you're still on the road. What I was talking about was the denial of dyslexia within the scientific gray space.
Okay.
The denial of educating kids.
Okay. I'm trying to figure out a way to say this and still be a nice person. Dyslexia is hard. I mean, I know we've talked about this. Dyslexia is one of the things that I have the most trouble figuring out. And I've had lots of different cases, lots of cases where the kids have had dyslexia, and every kid is so different, and there's different facets of it. And, some kids have more problems. The one of the seven thing, some kids have more problems with this, and some kids have more problems with that. And it's not this cookie cutter, every kid with dyslexia needs this one thing. So I think the complicated nature of dyslexia itself has been somewhat maybe overlooked. And I'm trying to think how to say this. It would seem that you would need someone very experienced to be able to make really good determinations and recommendations for dyslexia services for an individual child. So sometimes we have more cookie cutter-ish tests, I think, and that might be one of the problems. I'm trying to say this without saying this, I guess. I think it's maybe an experience thing.
No, I get that. And I do agree, because I think when people are trying to do evaluations, they're looking at the same set of evaluations across every single child. And you may not be using an evaluation which may be looking at certain facets. Like, I had to push for an evaluation specifically on orthographic processing, even after I had the FIE in place. And I should clarify, FIE is a Texas term, full individual evaluation, because I know when I've spoken to people in other states, they're like, FI what? So I think states tend to call the evaluation phase for IDEA differently. But I had to push for orthographic processing. Now I'm having to push for, they recognize that he has dysgraphia, but they've never tested him to see where his writing, at what grade level his writing ability function is at. So I'm pushing for that at the moment, which is just for my own knowledge sake, because you and I both know they don't know how to deal with dysgraphia, and they're certainly not.
I know. I'm getting ready for dyscalculia when that hits. I'm like, ooh, not even there yet.
I was an advocate for one parent in one of the many surrounding school districts in the Houston area. And I said dyscalculia, and they were like, no, we don't say that word. And I went, why not? They go, we don't say that. We say SLD in math. And I said, you're going to say the word. They go, no, we flat out refuse. We're not going to say the word. And I was like, watch me. You're going to say the word. You want to call it
SLD? This to you?
Yeah.
Oh,
I'll tell you which one offline. I'll text it to you, because I'm not going to say it on here. I'll tell you which school district. But they were just adamant. They were like, we're not going to say that word. And I was just like, you need to be saying that word.
We're not going to say the word.
Yeah. That meeting didn't end well. The parents got very angry. So, but it was just one of those like crazy things. And so I pushed for a new evaluation because of Texas getting into the legal trouble that it did with the Department of Education and the censure that happened. So I wanted very specific changes made to his IEP plan that they refused to do without doing a new evaluation, which I was like, fine, we're only a year and a half out from the other evaluation, but sure, let's redo it. So they redid it. Because my son is evaluated every March by a very specific facility, and the GORT is administered every single March, they administered the FAR as part of his FIE because they couldn't give him the GORT. Mm-hmm. Well, the FAR at least tells us a lot. I mean, it's not one that the district commonly uses. And it was so informative because it looks at things that the other evaluations that they typically use aren't looking at. And I'm always sort of dumbfounded by that process, but I shouldn't be, if that makes sense. I mean, maybe I'm always hopeful, and then I just, which is weird because I'm one of those people who always expects the worst, but hopes for the best.
That's good.
I think when it comes to evaluations, I'm always hoping for the best and then really disappointed when that's not what happens.
Mm-hmm. Yeah, but, especially when it's your kid. I just keep going back to the fact that dyslexia, there's just so much. And for me, it's one of the most confusing criteria that I deal with. And every single time I have to go through and research, and I learn new stuff. And I will tell you, though, that dyslexia moms do know their stuff. And that's where I know I've asked you questions, and I think I've asked you questions a lot. And because y'all know your stuff. There's a couple of parents who have kids with dyslexia, and then my parents who have kids with diabetes. And never been so, it may be epilepsy, but I've never been so impressed by the vast amount of knowledge these parents have acquired, and I get to learn it all. And it's, yeah, I like learning it all, but it's very, very impressive. And
Thank you.
so that's where I have to learn from my parents most of the time, because I honestly, I can't get all of that reading. I can't get all of what they know. They know too much. So, I've got these parents who this is their life, and you've got these cookie cutter tests, and yeah, I think it's just easier to do it like that for schools. The question of giving different dyslexia services to different children, I know that that's an issue as well. So, because, yeah. I don't know.
Yeah, I mean, I'll just say, that's one of the most frustrating things from a parent's point of view, is because, you take a kid and you stick them in a group and you assume every kid in the group is at the same level and has the same weaknesses and needs exactly the same kind of supports. And it's like, so structured literacy, yes, every child in this country, regardless of dyslexic or normative, it doesn't matter, would benefit from structured literacy. I'll enter into that debate with anybody that wants to enter into that debate. The science is there, the proof is there, case closed. But from a remediation point of view, to take just this unknown group of kids and stick them together and go, okay, we're going to stick you in exactly the same lesson in exactly the same place, and we're going to move you at exactly the same pace. Mm-hmm. That is never going to be an approach that works. But unfortunately, that's what our schools do, because they don't have the knowledge to be prescriptive per child.
Yes. And I was thinking about my daughter, and, she has Down syndrome. And I do think we've gotten away, from that, like, oh, all kids with Down syndrome, they need this and they go in this class. And now, to me, and to probably a lot of people, that sounds really nonsensical. Mm-hmm. But I'm willing to bet that back in the day, before I was practicing, that's probably how it was. Like, oh, you have Down syndrome, you go to room A. And that's not how it is now, and that's not how it should be. So I'm hopeful that the same kind of progress will be made with dyslexia and with other criteria. So
I'm very hopeful as well. Otherwise, I wouldn't be doing this. But I think it's important to note. I think it's important to note, though, how special education has evolved over the last 40 years. It's not the same thing that it was. Mm-hmm. I was 35 when I had my son. So he's 11. So yes, people, I'm 46. So, but when I was originally making the push for special education 3 years ago, maybe it was 3.5 years ago. I don't know. It was 3 years ago when I was originally making that push for special education identification for him. I went back in my head to my memories of the special education department when I was in elementary school. And, that's a very prejudicial view to take, but that was a very scary step for me to take, because it changed from when I was a little girl to what it is now. Thank God. And IDEA was a fundamental part of that change. But when I first started the journey, I didn't know that, and I remember so I did it. I got it. I was about to go into the first IEP meeting, hadn't told my husband a thing. And I'm like, okay, so honey, I did this thing. And he's 4 years older than I am, which means he went through school 4 years before I did. And so knowing what I was thinking in my head, I was like, oh my God, what is my husband going to say? What is he going to do? Is he going to be like, why would you stick our kid in special education? And he said the most profound thing to me at that moment. He turned around and he looked at me. He goes, of course you did, because that's where he belongs. He learns in a certain way. or he has to be taught in a special way. So of course it has to be special education, because he's not going to get that in gen ed, because they've bought into the wrong curriculums. They're never going to teach the kid how to read. We already know that. And I was like,
amazing.
Oh my God.
How'd you get that so fast? No, absolutely. My oldest daughter, older daughter, I have two. She's gifted, very gifted, and has ADHD. And I mean, in my opinion, it's the same thing. She should be in special education too. It's not. It's just she needs to be taught in a different way. And ever since she's been in a class with kids who are a little bit more like her and a little quirkier like her, it's been better, and she's had a lot of growth. And because she learns differently, she says a lot of weird things and really cool things, like I love how she is, but she's on a different level, and so she needs to be taught a little bit differently. And yeah, so I think in a lot of states they're actually they are considered special education. They get the classes.
So did we say, I know we talked about it before we went live, and now I can't remember if we actually said it or not. So one of the things we did want to say is a number of cases are applied to the Supreme Court on an annual basis, but not that many cases are accepted by the Supreme Court to be heard. Yeah. So the fact that Endrew F. actually made it to them, for people to stand in front of them and argue a case in front of them, is a very profound thing, because it really is so rare if you think about it.
Absolutely. And that was kind of going back to what we were saying about, oh my goodness, like all these eyes are on this issue that affects my kid that I feel like nobody cares about. And I'm in this community, so I guess I feel like my people could care about it. But overall, and if I wasn't in the community I'm in, I mean, I would feel very, very alone. And as parents of kids with special needs, I think we do feel alone sometimes anyway. But yeah, and I was trying to find the stats on how many cases are accepted. I just know that it is a very, very low percentage of the cases that are submitted. And I also know that for the attorney, it's a lot of work to submit the case, and knowing that you're probably not going to get accepted. So yeah, I mean, it's a big deal. I did want to say one thing, just too, because I know we've been kind of talking, and I want to make sure that I give just some recommendations or something. Try to be solution oriented. I don't think I was as much as I like to be earlier. So with respect to the complexity of dyslexia, in my opinion, I don't know if you think it's complexity more, but I do.
I do.
Just remember, and not you personally, but just I think it would be helpful to keep in mind that for everyone that after an FIE, after the school evaluates, there is always the option to ask for an IEE, which is the independent educational evaluation, and then go find someone who you trust, who can look at these things and give you a second opinion, and bring that to the school so you can the school doesn't have to go by it and implement recommendations or agree with everything they say, but they do have to consider it. And I would argue that they should consider it in good faith. I don't know if I would live on that, but yeah, because that is important. And I think we've talked about this, did a due process, my first one, on IEEs and how important they are, and looked at a lot of case law, and very important. And I know the Supreme Court has said, how important it is that parents are armed with that second opinion so that they have the information they need to go in and discuss their child, and not just giving everything over to the school to say, we evaluated, this is what we found, this is what your kid needs. And so definitely, if you're not real happy with the evaluation the school gave, go get that IEE. It's really not, I mean, I really don't even see it as that big of a deal. I wouldn't go get it just to get it because it is expensive for the school, and I don't want the school to have to pay for something they don't need to pay for. They've got a lot of other stuff to pay for. So,
Right.
but if it's going to be helpful, absolutely, that is your right. That's one of your rights, is to go get that IEE. And I think we talked about that earlier, how that process works. But I always suggest that.
No, and I agree. And based off of what somebody that I know very specifically went through in her district, what I tell parents that I talk about getting IEs with is I say, look at your school, and when you tell them you're getting an IE, ask them for the rules of engagement. And what I mean by that is this particular person that I'm referring to went and got, she said, I want an IE. The school said, okay, sure. She went, she got the evaluator that she wanted, went and got the IEE. The evaluator said everything that the parents had been saying, that the school, it was in direct contradiction to the school's evaluation. And then they get into the meeting where they're supposed to review the IE, and the school says, we reject it. We're not going to consider it. And she said, why not? And they said, well, you didn't do an in-class evaluation. And she said, excuse me? She ended up winning, but it took several meetings and engaging an advocate and just a lot of temerity on the part of the parent, and planning with me as well of what I know about IDEA. And they ended up making a mistake that I went, that's your crux right there. And you tell them that the IE is still on the table because they just said this and that, no. So they can't reject the IE and stick it back in there. And so she did, and she won. But because of that, and she consults with parents as well. And because of that, what we tell parents all the time is, go get an IE if you feel like you need to have an IE, but look at the school and say, what is it? Tell me all of the criteria that you are going to require in order for you to consider the IEE, because I don't want to go get it and come back and you go, no, we're not going to consider it because of X factor.
Yes, absolutely. It's funny. I had a case, ended up settling, and I won't name the school district or anything, but where the IEE provider didn't do some things like that. And I don't remember, I think one of them might have been an observation, but instead of telling the parent, hey, we're not going to consider this because, there was no observation or whatever, they didn't tell the parent and just looked at it and didn't really consider it, and wrote as much in emails internally. And the parent thought she had an IEE that, and the school paid for it. And honestly, she kind of, she lost out on her right to an IEE. And again, that case, settled fine, and it is what it is. But another thing is, a lot of times the schools will send kind of those rules of engagement. They will have that in their contract with the IEE provider. So, because the schools will have contracts with the IEE providers, and you can request those. I mean, I don't see why that should be hard for you to get. Sometimes they just don't want to give them to you, but I've gotten them. So, and that will kind of outline what they're supposed to be doing. And so, yeah, like in that case, I don't know if they had, a contract or whatever, but if they did, that would have been interesting to see what they outlined that the person was supposed to do. So
that's good to know. And I know she's going to listen to this, so I am expecting that she'll probably send an email within about an hour of watching this, asking specifically for that document. So.
Yeah. Sorry. But yeah, the contract. I'm
probably already IMing me.
I'm gonna backtrack. They have the rules that they'll send to the IEE provider, and these are the things you must do. You must use the most current evaluation methods. So there's a WISC 5, so don't use WISC 4, and those types of things, and it might go into observations. But also they should send the parent, when you request the IEE, and you don't have to do it in writing, but it is beyond recommended that you do it in writing, and just say you disagree with the evaluation. I know that a lot of times you don't have to say why you disagree with the evaluation. And I know that a lot of people are very, very hesitant to give that information to schools, like, this is why I disagree. I am just the way I roll. I am extremely, probably know this, I'm extremely transparent. And I personally have no problem in my personal life or professional life in saying, this is why I disagree. And I have no problem with them coming back and trying to fix it. I know that there's some lost trust between the parties. So, when I have a client, that has to be dealt with. But personally, I think it's a great idea to work with the school. If you think they did something wrong in their FIE, I always like to be given a second chance. So, and I have seen schools come back and do extra testing and fix what they did. And, and then that's actually really good for the rapport between the parties.
So I would agree with you, but I think from an unsure perspective, that's probably why people don't want to be. Is I know when I began this process and I very first pursued an FIE, I didn't go down the IE route because I already had a private diagnosis. Mm-hmm. So I knew what I was going after. And FIE happened to almost word for word mirror the private diagnosis that I already had. Mm-hmm. But I got really lucky. But I wouldn't have said that I disagree, because I would have been unsure about my position, because I didn't know then what I know now.
And that's okay. I see where you're coming from. If you'll give me, I'm going to plug in this real quick. If you'll give me a second, it died. It's a Mac. It died so quickly, and it's like, give me a second. I thought I did this earlier.
No worries. So for everybody still listening, I hope this is helpful. We're going to wrap up in a couple minutes, but Holly is such a great source of information. We end up to usually just keep it on going.
I kind of geek out a little bit sometimes. So for the here's the thing with the IE, you need to disagree. And if you don't know why you disagree, just because
it doesn't feel right, it doesn't feel,
and I get that. I really get that. And that's it's also very helpful to have other people look at this. We all have friends. We have friends who are, have kids with different special needs, and some of us have doctor friends or psychologist friends, or whatever. Maybe get someone to kind of look at it and say, or maybe ask the school questions about it. Like, I'm uncomfortable with this. Can you answer this? Because they should have a meeting with you to go over this FIE. So that's helpful. Now, if you just disagree because you don't think that they were thorough, and it's very hard for you to articulate, and I get that. I've been doing this a little while, and I sit here and say, oh, I want to say exactly, and that's my privilege to a certain extent. Like, this is what I do, so I do need to be brought back. Like, not everyone does this every single day, personal and professional. And so, yes, I can see where it's going to be hard to say that. So, no, you don't have to say exactly why. If you're uncomfortable just because it's hard for you to articulate it, then no, just say you disagree. I guess what I was getting at more is I don't see a reason to hide the ball. And so that's really what I was talking about. It wasn't where it's really hard to explain.
No, and I didn't mean to imply that, because I think that you're absolutely right. And I didn't know you 3 years ago.
Or about like
But like I said, I didn't have to go through the IE route, but like the people that I know that have taken the IE route, you know, most of them have done it because they just didn't feel like it reflected their child.
and that's
You know, they're saying my kid doesn't need any help, but my child is more than 2 years behind in reading. The anxiety level is over the top. They cry every single night when they're trying to do their homework. They're shutting down. My child is slipping away from me. How can they say?
Well, that, in my opinion, is an absolutely valid reason to disagree. Like,
yep.
They came back and said, my kid doesn't need help. I know my kid needs help. Yeah, that might be something that's hard to put on paper, and you don't want to, pigeonhole yourself in, because you don't know what they may have done insufficiently, and so I totally understand. And I'm not saying, and I'm glad you asked that. It's a really good clarification. I was only, going at
right.
If you've got a speech and you've got the entire gamut of everything, and you're really just worried about the speech, just worry about the speech, but a lot of times we aren't, we want everything, and that's valid too. So mine was more of just like, I don't see a reason to hide the ball.
Right. And just to kind of give some random examples, like a parent goes in for an FIE, or, I need to stop saying FIE. The parent goes in for the evaluation under IDEA for dyslexia, and then the school comes back and says, your child isn't dyslexic, your child is autistic. And, that's the source of all the problems. I mean, case in point, take the due process thing that's been going on in Dallas ISD for like the last year, even though I know of instances here within the greater Houston area as well. And then, you have different cases where the child melts down in the middle of the court, and it ends up being dismissed as, oh, they melted down because this was beneath them, and so the child doesn't have any problems. And the child melted down because what was being asked was too much, not because it was beneath them. Mm-hmm. Certain things, like if the child is melting down, why is the child melting down? Had a conversation yesterday about all of the behavioral issues that come up as a result of denials, and how then the child gets pigeonholed from a behavioral perspective and has behavior goals, or they keep insisting on behavior goals when that's an effect, not a cause. And even moving the child from a public school to a private school that may deal with their LD may not necessarily be dealing with the cause, or with the effect, the emotional effect now, the long-term ramifications of those emotional effects. And I don't want to go down that rabbit hole because we're already like an hour in, and we could talk about that particular piece for like an entire another hour. But I like that you brought up the fact for the IEE, and I love that you want to be transparent, and I completely agree with you. I want to be transparent as well. I just know, at least for me in the beginning, and I should say I'm the youngest of 3 children. So I'm a little sensitive about being told that I'm wrong, even though that I know that I'm really smart and I know what I'm talking about.
I'm always right.
And so fortunately, I have enough knowledge at this point that if you want to tell me that I'm wrong, I'm going to go, okay, prove that I'm wrong, because I know that I'm right. But at that particular time, if they had A, denied his dyslexia, and B, looked at me and gone, you really don't know what you're talking about, I would have been like,
yeah,
but and that's a big thing that we at least encounter with the Dyslexia Initiative, is trying to encourage the parent. If your inside is going, but you need to start. You don't have to tell them why, just push.
Yeah, and very, very glad you said that. And that's another one of those things that sometimes I need to be brought back, because, and I'll be honest, like, I do other people's stuff way more than I do my own. But when I go to my daughter's, like, I wouldn't say I'm intimidated, but I am scared for my daughter. I am, yeah, I think that. But I forget about the intimidation factor. And so I have to really work on being, empathetic, and thinking about someone walking into a room of, 10 people, 15, 20 people. And when I go, it's like 20. I'm like, oh my goodness. everyone come? It's just so weird.
You're an attorney. They probably always have somebody present just because you're an attorney.
They don't bring an attorney. I will say that. I am actually, my ARDs, like, they're really not, it's not that big of a deal to me. Like, I am not a fighter in that way. I just get along. I have fun. I don't know. But I mean, I'll do what I have to do, but they seem pretty chill to me, but I don't know. Maybe not. So, but I do forget about the intimidation thing, because I think when you do something over and over and over, it becomes much less intimidating. And, you know, and as parents, you know, you do it over and over to a certain extent, but maybe once a year, maybe twice a year, you know, and you really don't feel like, you know, I always feel like I have some recourse, like you know, and I think when you don't feel like you do, or you don't know what it feels like, that can probably be scary, which again is kind of why we're doing this. And hopefully, you know, helping people to feel less intimidated and more, you know, confident. And man, what you just said about the gut, and I am not going to be sexist right now, because but I know as a mom, and I'm sure dads had the same thing in their own way, but as a mom, I know, like, there's something I feel, and he's right, and he's cute.
Somebody's needy baby, greedy baby, and is tired of me not paying attention to him. Sorry.
But that gut feeling, I think it's real. I think it's absolutely real. And I ask my clients their gut feeling all the time. I'll ask them, and they'll give me facts. And I'm always like, no. I don't want facts. I want to know what you feel. Like, I want to know what you know is real. What's going on?
Definitely. So my 3 dogs are about to go bananas because one of them's out of the kennel and the other 2 are in, and the sun is shining and it's playtime. So, but we've talked about a lot. I think we've had a really great conversation today, and I always love talking to you.
I can talk way too long. I love this stuff, but yeah, we should do this again.
We should. But I'm sure that we'll come up with more topics and do more. We don't have anything else planned right now, but it's just the beginning of the school year.
Maybe people will get
we should probably have it. I know a lot of people are asking us a lot of questions. I'm seeing it in really all of the dyslexia groups. We should probably have a conversation about compensatory education, but that needs to be its own session. So let's I'll message you about that. But
there's a lot of things that go into that, and I've been mulling over that in my head. So
so I'll message you. We'll schedule that one, because that's a huge, especially as we continue in virtual learning.
Yeah, and we talked about the mock-up hearing or something. So.
Yeah, we're definitely going to do that too. All right. But thanks for joining us. And we're going to wrap up here. And everybody have a really great weekend.